I suggest we go ahead and start, John. So, over to
we have
you.
the first questions. The next slide, please.
Yeah, well, you asked me.
Right, Tim. ICA arbitration is said to be an impartial means of resolving contractual disputes. I mean, quite frankly, in your terms, what do you think that means?
Well, ICA arbitration is based on the concept of no-fault dispute resolution. So, the purpose is not to apportion blame or to find fault, but rather to restore both parties in the same position that they were in at the time the contract was entered into, or if no contract has been entered into at all, basically, is to restore both parties to their original position. That is the concept behind ICA rules.
So the ICA bylaws and rules, if you have a look at the second questions on screen that everybody can see, is not being or will not be performed for any reason. What does that mean in practice? I mean, can you give me some practical examples?
Well, the word cancel does not exist in our rules, technically. Instead of cancel, we always refer to invoicing back. And we invoice back in accordance with the rules, specifically Rule 237 and 238. So, what this means is that in the event of a dispute between the parties, the starting point for resolving their differences will, of course, be the terms of the contract between them. Something I would add, because it actually came up in the last meeting, is that if there are specific clauses in the contract that are different or speak in a different way to the rules, the contract always takes precedence, which is very important to note.
Because that's basically a meeting of minds, a consensus ad idem. And so if you've got standard terms in a contract, and then you've got specific terms that have really been agreed, then those will, on the whole, take precedence over the rest.
Exactly.
So look,
actually, we're going to do Q&A after the, if you don't mind.
What I try and do is make this interactive. So before I'm going to ask Tim the next question, if I may, Mr. President. So can any contract be referred to ICA arbitration? Now, who's going to, among here, think that, please put your hands up, can any contract at all, can anything, any contract be referred to ICA arbitration? All those who say yes, put your hands in the air. All those who say no, put your hands in the air. Well, Tim, what do you say?
Well, the correct answer to that question is that in order for an ICA arbitration to take place, there must be a bona fide clause in the contract that specifically refers to ICA bylaws and rules. So unless there is an actual clause in the contract referring to our rules, then an arbitration cannot take place under ICA rules.
That's right. So do you get that? ICA. So put International Cotton Association into your bylaws and rules, but you will be able to get that contract referred to it. Of course, we don't deal with confectionery, we don't with steel. We deal with cotton, and we have had some contracts where people have tried to put those towards us, and that we don't deal with. But Tim, what can a party in arbitration expect of ICA arbitrators?
Well, that's a good question. Under Section 33 of the Arbitration Act of 1996, there must be a check as to whether there are any conflicts. There is a code of conduct, specifically Halliburton versus Chubb, for example. ICA arbitrators must be well versed, of course, in their duties, especially the need to act fairly and impartially. Hence, I come back to, are there any conflicts? Is there any reason that would cause you not to be able to act fairly and with impartiality? That is vital. They must be proficient in spoken and written English to a level that enables them to put forward their views, engage in a debate, speak about the merits of a case. They must have at least 5 years experience in the trade, a minimum of 5 years. And there is actually a very disciplined process before somebody can become an ICA arbitrator. It's actually a 4-step process which guarantees a qualified level of knowledge and expertise. Basically, you have to take exams put forth and obviously pass them by the ICA.
And they're very tough. They start off very, very gentle, and many of you have taken the basic exam. But then you have level 1, you have level 2, then you become a probationary arbitrator, and boy, once you take level 3, it's university standard. Tim, you took level 3, it was hard, wasn't it?
Oh, it was, yes.
And it's intended to be hard because we only want the best of the best dealing with cotton arbitrations. Can we have the next slide, please?
Yeah, what's waiting for that to come up? I mean, one thing I will say is that ultimately you are producing a document that has to stand up under English law in the cause of law. So you absolutely have to know what you're doing. It needs to be a rigid and disciplined process. Yeah. Oh, good. No, well, now it's my turn to ask John a few questions. John, can you tell me what it takes to commence a technical arbitration claim, please?
Okay, I'll start off, if I may, with the fact that some people think that all arbitrations are the same. It isn't. You've got quality arbitration, where you're looking at the quality of the cotton. We have very few of those, though strangely enough this year we've had an increase in the small numbers we get. And then you've got technical arbitration, which is basically everything else. It's the contracts. It's the claims for carry and so forth like that. And in order to commence a technical arbitration claim, you have to go online. How many people here have applied for arbitration? Well, okay, thank you. You go online, you upload a contract, you pay the fee. If you're not a member, and I recommend you become a member, you're paying a £15,000 application fee. And you also have to pay a £10,000 deposit. That is against the arbitrator's fees, because the arbitrators, wonderful guys that they are, won't work for free. Let's face it, they're putting in many hours. And also we take some money out of that as well for our stamp fees, and we'll come into this in more detail. But basically, you apply, you get an invoice, you pay, and then basically we will commence the arbitration when we have the money. Because as in everything in this world, unless you pony up the money, then the pony doesn't run.
Well, thank you, John. John, did you mention what the fees are if you are a member?
Oh, good point. We have a situation where they could be, quote, free arbitration. In other words, you don't have to pay the application fee. And so that's why it's important that you become a member. And you have to be a member for a year to get that free arbitration, because there were far too many people who were joining ICA for the arbitration, so they didn't have to pay an application fee and then popping off the next year.
So, John, if I've only got a small claim, is there a way that I can get it looked at faster? Is there a level at which one is considered a small claim?
There is. It's called the small claims process. Again, it's technical arbitration, and what will happen is that if it's under $75,000, then you can get one single arbitrator to look at it, so you're only paying one set of fees, so that's a lot cheaper. The fee, if you're not a member, is very much cheaper as well, though of course if you're a member it's free arbitration, as it were. And quite frankly, it's looked at much, much, much faster. I've seen some sole arbitrations that have taken literally 2 months from start to finish for small claims.
Okay, next question. John, can a non-registered firm use the ICA arbitration service?
Many people have asked me this question, and they think that, and in fact we've had respondents in arbitration, that's the other side to the claimant, so you have claimant, respondent, who said, oh, well, we're not members of the ICA. Because we're not members of the ICA, there's no way that we can have arbitration, because you have to be in the club, you've got to be members of the club to have the arbitration. Not the case. You don't have to be a member. Absolutely not. And so a non-registered firm, a non-member, can use the ICA arbitration, though it costs a lot more money. So, again, become members.
Talking of money, is an ICA arbitration expensive?
No, it isn't. Let me tell you a story. If you went to the English High Court and you were to bring a similar case, a full technical arbitration, you're probably talking £250,000. And even to start the case, you're talking lawyers will not get out of bed and the judges won't be awake, short of £50,000. For us, our average arbitration cost last year was about £6,712. I believe that's the figure, and it is cheap and it's fast. Because, and I'll make this point later on again, we are fast in comparison with the courts. Tim, you'll remember a court case, we won't mention names, that the ICA was involved in. And we went into the English High Court where we successfully defended a claim. And would you believe it, that claim rumbled on for 3 years. 3 years. We do it much faster.
One question that just occurs to me, John, is that, and I'm going off script here a little bit, but if you've got a contract with a bona fide arbitration clause, you are bound to first pursue the case by arbitration. You cannot go immediately to the High Court. That's correct, isn't it?
That's absolutely correct. And we've seen on a number of occasions people who've tried to go into the Indian, Pakistani, Bangladeshi, and even the English courts first, and then they've been what's called non-suited. They've been stopped dead. Why? Because you've already chosen in your contract ICA arbitration. So you must do that first before you go to the courts if you think that there's a problem with the way it was produced. But that's a good question. Thank you very much, Tim.
So who pays the arbitration costs?
There is a rule that if you're the winner in a case, then you shouldn't have to pay the costs because you've won. So what happens is we have costs follow the event, and that basically means if you're the winner, you get the other side who's lost to pay the costs. So, for example, a big company wins a case in arbitration against another big company, and the big company A has paid all the costs because big company B has not paid a single penny. In the arbitration award, the arbitrators will nearly always, because costs follow the event, it's a useful phrase to memorize, they will make sure that company B has to pay the costs that company A have expended in the arbitration. For example, the application fee, the arbitrator's fees, the stamping fee, the courier cost, the legal cost, all the stuff that goes into it.
Thank you, John. Okay, so for the sake of those who may not be familiar with the ICA arbitration, could you just briefly give us an idea about the process of the arbitration at the ICA, please?
No problems. And this is really where we're getting to the nitty-gritty, but this is what people have asked in forums before. Tell us what actually happens in arbitration. So I've already mentioned the fact that you will apply online with uploading your contract, and then the arbitration team, of which I'm head of arbitration, and Lynn Thomas, who you've probably seen on reception, is the arbitration officer. She will then put into process the obtaining of the invoice. The invoice is then paid by the claimant to make sure that they have put the money in for the deposit, the application fee, and all the rest of the costs. We then make sure that the other side choose their arbitrator, because a key thing about and the difference with English High Court is that you could choose your own arbitrator. So in your application, you'll choose which arbitrator of the 28 or so we've got you want, and then they are your chosen arbitrator. The respondent, who's the people who responds to your claim, hence the word respondent, will choose their arbitrator, and then Mr. President was doing this all last year. He will then choose who's going to be the chair of the tribunal, because there are always 3 in a full technical arbitration. So think about that 3, and they're all neutral. You may have appointed them. You may think that they're your person. No, they're neutral. They are judges. They will always look at the facts of the case and give a neutral, unbiased award in the end. So what happens is, and I'll be coming to this again later, you put your claim in, the respondent responds to that, then there's another response you can put in, answering what the respondent has said, and then finally the respondent says, well, I want to say something about what you've done. So we have this thing called 2 bites of the cherry. So you've got 2 lots of submissions, and then if the tribunal is happy with that, you basically can extend it, but it's not really something, it's very rare. You haven't extended it many more times.
No, it's very rare. I mean, now there may be occasions where and there often are occasions where the tribunal will ask for certain clarification. basically whatever comes into the forum of the tribunal is copied to both the claimant and the respondent. It is a very open, transparent environment.
That's right. Transparency is the key thing in ICA arbitration. Have I missed anything, Tim, do you think?
No, I think you've covered that quite well there, John. Thank you.
Very, very kind. Could we have the next slide, please?
I think this is your question to me.
Okay. So tell me, you are a chair of a tribunal. Give me an idea about what you do, because you're paid an extra £250.
Well, I've chaired countless tribunals. I believe that one of the most important tasks that a chair can do is to ensure that procedure is strictly followed, and also that the whole process stays moving forward. Because I mean, there is a responsibility, not just for the chairman, but I mean for the tribunal as a whole, to produce a bona fide, accurate award on a timely basis. So the chair very much oversees that process. I'm trying to think if there are any other particular.
How about chair's directions?
That's right. Actually, I mean, once the tribunal has been formed, then the chairman sends out chairman's standard directions to both the parties, which specifies timelines and also gets the whole process moving.
So after the points of claim have been sent into the ICA, what happens next?
Well, what happens next is that receipts of the particulars of claim by the ICA are received typically by email from the claimant. The ICA then paginates the particulars of the claim to the tribunal and to the respondents. And here comes in these strict timelines. The respondent has 14 days within receipt of these first submissions to make his or her response. This can be extended if there is good reason to do so, but that is at the discretion of the tribunal. So on receipt of the response to the claim, the ICA arbitration team send the respondent's reply to the tribunal, and then the claimants are given 7 days to respond to the respondent's submissions. And as John says, both parties have 2 bites of the cherry, so there are 2 sets of submissions. Probably appropriately, the respondent is given the last word, actually.
That's absolutely right. And again, that's part of really English law and fairness. But tell me, in your experience, what if there's no response to the claim and you get a situation where the arbitration team have sent the claim of the claimant over, they've sent the contract, and there's radio silence, even though we know that they've got it, the claim, the respondent's got the claim, because we've couriered it to them and we've sent it by email. What happens?
Well, unfortunately, this does happen, and as I mentioned earlier, the onus is on the tribunal, and particularly the chair of the tribunal, to move the process along. So, provided that the respondent has been given ample and every opportunity to make his or her case, if there is still, as John put it, radio silence, then the tribunal will advise the respondent and the claimant that the whole process will proceed, and it's a legal term, ex parte.
That basically means you proceed on just the information that you've been given by the claimant. And so that's going to be a fairly slam-dunk case for the claimant, isn't it? But if the respondent does respond, and this is reinforcing what we said again about the 2 bites of the cherry, it's a useful phrase to remember. If the respondent does respond, can the claimant answer what is said in the response?
Well, yes. I mean, if the respondent does respond, then the answer is yes. The ICA arbitration team send the claimant's further comments to the tribunal and to the respondents for comment within 7 days. Upon receipt of the respondent's final comments, they're sent to the claimants and the tribunal for information only. This ends the submissions process, excepting any inquiries such as on price or some other question that the tribunal may have in specific regard to the documents or even the contract.
That's great. Thank you very much. Could we have the next slide, please? Now, again, you've had extensive experience of being an ICA arbitrator. First, if you don't mind, just give me some, well, tell us the story.
Well, this really does actually age me, but the ICA asked me recently, how long have I been doing arbitrations for? I believe I did my first arbitration prior to 1990, but I certainly have been doing arbitrations all through the 1990s, so I've been doing this for, what, 30 years. I've served for a number of years on the Rules Committee, which I've often said is the real blood and guts of the association. I mean, that's an exhaustive process to look at the rules, make sure that they are fit for purpose, that they are current. I've also been on the, and continue to be on the Arbitration Strategy Committee, which is a little bit like the High Court judges. There are 12 of us, 10, no, 12 of us, isn't it?
10, but as you quite rightly point out, there's 2 other people who sit on it who aren't members, such as Bill and myself, who...
So basically, these are the most qualified arbitrators, undoubtedly with extensive experience in the trade and also extensive experience and knowledge of the whole arbitration system. So as far as arbitration work is concerned, yes, I've been doing it for a long time, and I hope, knock on wood, I'll continue to do it for a long time to come.
Well, perhaps if I can go a little bit off-piste on this one and ask, I mean, in your experience, when you started off, from what I hear, and I don't want to lead you, but people were telling me that the cases were an awful lot simpler and more sort of slam dunk than they are these days because of lawyers intervening. Would you agree with that?
I would say, generally speaking, yes. Like many things, our trade can often become more and more complex. The rule book, I'll bet, is a lot thicker than it used to be. In fact, I do remember that the old rule book used to be so horrible to try and find your way around, and wasn't it Derek Tanner who put it in some sort of semblance of order so that regular human beings can easily access the rules, right?
That's exactly right. In my time, and I've only been doing this since, well, I was notarizing for the association from, I think, 2009, but only officially employed full-time from 2013. And I've noticed their cases massively getting more legal because lawyers, and we'll be coming onto this, we try and discourage lawyers getting involved in the ICA process. Tim will tell you why, because, well, they're a pain in the bum, quite frankly, and they're not cotton people. They don't know the cotton industry. All right, I admit I'm a barrister and a notary, but the thing is the cases have become incredibly more legal over the course of the past few years, in my view. But anyway, I've gone off piece, forgive me, Tim. So look, do you have a big room in the ICA in which the tribunal sits to decide cases like in a court?
In a word, no, we don't. I mean, obviously, the ICA offices are based in Liverpool, and the ICA directorate staff, they keep the arbitration moving, make sure that the awards are stamped. But the fact is that, well, in this modern age, arbitrators are actually all over the world, and typically we meet by Zoom or Google Meet or by conference calls. So, no, there isn't some great big austere-looking room where the tribunal, 3 of them all get together. It's done a lot more in a much more modern fashion these days, and as I say, typically by Zoom.
That's exactly right. So tell me, how is the award published? I mean, can you just give me some idea of the process? We've already heard about the 2 bites of the cherry, so there's a submission stage, and then there is another process because you've got to produce the award being the final decision of the arbitrators.
Once the chairman and both arbitrators are content with the award after it's been carefully checked by all 3 members of the tribunal, then the award will be signed by the arbitrators. It will be stamped by the ICA, and as John mentioned earlier, there is a stamping fee for that, which is typically £800, isn't it? But then
exactly right.
Yeah. And then the award becomes effective upon the date of the stamping. Any unpaid fees will cause the award not to be released. So all fees need to be settled. And actually, on that note, if you've got a respondent who is non-participatory, then the claimant will end up paying the fees, but then that will be added to the total cost of the award from which he can collect from the respondent, ultimately in a court of law, probably.
Costs follow the event, and that's a very important thing to remember. But if you've got a good, strong case, and you want to sue somebody, and you've got the right to come to the ICA, then take it, because the costs will be paid by the other side. Of course, there's always times when the other side might be a man of straw, as we call it, a company that's done a flit, as I don't know if anybody knows that Yorkshire phrase, when they've actually gone and moved away, or they've dissolved. But on the whole, you can get the costs. Well, with your permission, could you ask me the next question? Because I wouldn't mind dealing with that, the appeal process.
Oh, with pleasure, Mr. Gibbs.
You are very kind.
Here we go. So is there an appeal process? Could you explain that? Because it's a little bit more complex than the first tier process, isn't it?
There is. It is massively more complex. What happens is, if you put in your notice of appeal, say you've got your award, and you say, "Blummy neck, I don't really like this award." Say, for example, you're a respondent, and you haven't responded through the course of the first tier tribunal. This is your right to, when you get the award, say, bang, I wish, please, to appeal against this award. And you can, because we have an appeal process. And the appeal process, as soon as you put the notice of the claim in, you then have a certain amount of time to pay the application fee. Again, members don't have to pay the application fee, so please become members. The application fee, if you're not a member. You have to pay the deposit of £10,000. And also, very importantly, the amount of money you condemned to pay in the first tier award that you're appealing in costs. And so we have all that money in place. And then once that money is in place, the directors of the association will appoint a technical appeal committee. And that technical appeal committee is made up of 5 arbitrators from our pool of arbitrators, our qualified arbitrators. And they will look at a complete rehearing of the case and produce their award. Typically, I have to say, technical appeals are done faster than, in fact, first-tier awards. I don't want to labour that point too much, but I think it's because what happens is when you've got 5 people, you can spread the work. You can make sure that things are moving faster, because there's usually a focus in the appeal of specific points rather than the whole thing of the case, even though it is a full rehearing of the case. And so you can focus on those things. But the appeal process means that once you've got that and they produce another award, and I think, Tim, you've been chair of a number of technical appeal committees.
Many times, yes.
And you've written the awards on a number of occasions. And on those occasions, we have been in a situation where people who, once you've published it, have been extremely happy with the award, and you probably have not come across this, but on other occasions, with other chairs, parties have not been happy. And what has happened is that they've then they can go to the English High Court and try and overturn it. But this is a key point to remember. You can't do it on a point of law. These gentlemen and ladies who are our Technical Appeal Committee and who are our arbitrators are cotton people dealing with cotton disputes for the cotton industry. They shouldn't be considered to be, even though they are extremely knowledgeable in English law because they have to take a huge amount of examinations, they're not expected to be King's Counsel, you know, the standard of lawyers who are judges, because that's not your role, is it? You are cotton people.
No, that's correct. I mean, the whole beauty of the arbitration system, if that's the right word to use, is that you are judged by your peers, those who are expert and knowledgeable specifically in the trading of cotton. And that's why it's an efficient process.
And that's why people are choosing it. And that's why I think that they will choose it for the next few centuries. And they have been choosing ICA, well, before that, Liverpool Cotton Brokers Association, Liverpool Cotton Association. They've been choosing it for going on for 200 years, since 1842, when we were founded.
But 1841.
1841, forgive me. I'm glad the president corrected me on that one. That's very good. So, Tim, why do bylaws and rules not cover all incidences and occasions of trading? And I know there are at least 2 people in this room, and I won't look at you specifically, who've asked me this question and have said on Rules Committee, for example, why don't we cover this? Why don't we cover that?
Well, I mean, the real reason is that, as I mentioned earlier, for an arbitration to take place under ICA bylaws and rules, there has to be an arbitration clause in the contract. Having said that, the contract governs first and foremost. So if there are specific clauses in the contract that might differ from arbitration rules, then the terms of the contract will dictate. For example, you could even have a circumstance where the contract says ICA bylaws and rules with the exception of rule blum blum, or the exception, exactly. So it is important to note that the first port of call, per se, is the contract itself. So that's really the straight answer to that question.
Absolutely. And also, let's face it, you've mentioned already about how much better this is now, but it grows and grows and grows. And as those of you who are in the session just before this with the AGM, with the new bylaws and rules, it can't be expected that every single situation in the world where you're going to be facing a problem is going to be in the rule book, because if it was, then the rule book would start from here and probably end about here, and that will be double-sided as well.
Probably.
So, force majeure and cotton claims. You certainly know a lot about this, and you've dealt with it, especially following the COVID instances of 2020. So, over to you, Tim. Any thoughts?
Well, yes, and also when all of a sudden that post-contract there are export bans or import bans that are brought about by governments. It's important to note that according to ICA bylaws and rules, there is no such thing as force majeure. Now, having said that, if a contract cannot be completed, then we go back to the invoicing back procedure to place both parties in the position they were in the day the contract was entered into. Only if an appropriate force majeure clause is contained in the contract, and here we go again, the contract terms dictate, not the bylaws and rules, but if there is a specific clause in the contract, and here it needs to be very specific and leave no doubt whatsoever, words to the effect of the contract will be cancelled if such an event occurs with nothing due, either buyer or seller, it will be closed out at par. Words to that effect. But if that matter is disputed, which quite often it is, you've got to be very careful with these clauses, then the arbitration tribunal will decide.
That's exactly right. We don't have force majeure in our bylaws and rules, and we'll take questions on that later on if you want to. Could we have the next slide, please? Now, this really is a masterclass looking at a person who's been an arbitrator for so many years, who will be sort of, well, the two of us will work, and so you will be better prepared, hopefully, when you're preparing your claims after this session to do what is best to support your case. So next slide, please. First question. I'm preparing a claim to submit the arbitration, but none of the contracts have been signed. Does a contract need to be signed to be valid?
In a word, no. According to English law, and it's important to note and to reiterate that the bylaws and rules are actually under English law. According to English law, a contract does not have to be signed. A contract does not have to be stamped. The actions of the parties will dictate as to whether an agreement was in place. Now, that's not to say that I recommend that people get lax when it comes to both parties signing the contract. Ideally, contracts should be signed and stamped. But the fact is, even if they are not, and for example, there is an exchange of communication, there are letters of credit that are opened, there's all sorts of evidence that clearly an agreement existed, then that should be enough to be able to proceed to arbitration, provided that you've got a valid arbitration clause in your contract.
So what do I have to provide in my claim, and how do I do it? Because I remember you were telling me some time ago that sometimes you used to get, in the old days, plastic carrier bags full of paperwork, and the arbitrators were asked, go sort it, guys.
Yeah, I would not recommend just sending a shoebox with loads of papers in it to the ICA. it will cost more money because the tribunal will have to go searching through the shoebox and putting it in order. B, you need to clearly state your case. So there is a certain expertise in doing this, and this is why quite often it's good to have somebody with whom you can consult, who knows what they're doing. But the ideal way to present a claim is, well, first, of course, you send in your contract, but having a cover letter explaining very briefly, telling the story of what happened, and then leading to the point of we claim this much for market difference, we claim this much for carrying charges, we claim this much for cost and this much in interest. Specify it, spell it out. It needs to be very clear.
Absolutely. And the points of claim, these are literally your claim points, the points that you're making in your claim. Make it absolutely clear. And if I'm a respondent, for example, to those points of claim, what should I say?
Well, I mean, to respond to a claim put forth by someone, you obviously have to defend yourself. If you believe that the claimant has misrepresented the case, that there has been genuine reason for confusion, then step by step, in a very clear, logical, methodical manner, you respond to each one of the claimant's points and explain why you disagree with those points. You defend yourself.
Now, thinking about the second bite of the cherry, remember we've used this phrase before? What if something else, I want to say something else if I'm the claimant after I've put my claim in, my points of claim, or if I'm a respondent and I've put my response to the claim, do I have an opportunity to say anything further?
Well, we've talked about this before. I mean, the two bites of the cherry in arbitration. Put differently, there is an opportunity for the claimant to make his submissions, the respondent to answer to those submissions, the claimant to then come back with his final claim or response, and then under English law, fair play, the respondent is the one who is allowed to have the final word. Now, as we've mentioned, if the tribunal deems it necessary, the parties can make further submissions as a matter of routine, but that is at the discretion of the tribunal. Typically, you have two opportunities to make two sets of submissions.
We've emphasized this point so many times because it's really important. But then, to reiterate something else we've covered, can't I just courier the whole set of papers in the shoebox? The answer really, I guess, is no.
No, no.
Next slide. Okay, and this happens increasingly now. Can't I just use my lawyer to do it all and submit the claim, and get the lawyer to submit the claim?
Well, that's an interesting question, and the answer is a little bit twofold. Yes, but actually no. I mean, discuss bylaws forbidding submissions from lawyer to ICA is what I've got noted down here, and basically we keep lawyers out of the process as much as possible. They tend to confuse the process rather than help it. There is a list on the ICA website of those who are ready, willing, able, qualified to do consultancy. So people who are expert in the trade and expert in the rules would be a much better way to go rather than start hiring expensive lawyers who don't know anything about cotton other than putting on a t-shirt.
Absolutely, and in fact, if I see a law firm has put in a claim on behalf of a cotton company, I will instantly reject it, and I have the power to do so underneath the bylaws and rules. I will say, sorry, your lawyer cannot submit. Why? We want to keep lawyers out. They're expensive, if you say, Tim, aren't they?
They are indeed, certainly, yes.
So, is there an alternative to arbitration, bearing in mind, well, is there an alternative?
Well, there is an alternative to arbitration, and I would say this before I go on to say exactly what that alternative is. A negotiated settlement, in my experience over many years, is always better than a forced settlement. So arbitration, in many ways, should be the last resort, because you really have reached an impasse where both parties are cemented in their view as to who's right and who's wrong. The alternative to arbitration would be mediation. And there are qualified mediators that could be appointed to take a look at the case and try and work out that negotiated settlement. So it's not just arbitration, and my emphasis would be always try to negotiate it before you go to that final point. Now, having said that, sometimes there are legitimate differences of opinion, and even the best of friends can have a different opinion, and they can agree to disagree, and therefore they go to arbitration. They both feel equally adamant that they are correct. So it doesn't necessarily mean you've fallen out with your best friend because you go to arbitration, but my suggestion would be explore other avenues before you actually reach that point, and consider mediation.
Absolutely right. And remember, if you've got ICA bylaws and rules written into your contract, you can't go to the English High Court directly. It's only afterwards. So, I've won my award. What happens next? Enforcing, I think.
Well, enforcement of the award. So I've won an award. I've got X number of pounds that have been awarded. And so I go to the losing party and I say, okay, I will give you X number of days to settle this award in its entirety. If the party does that, then we move on. If the party does not, then ultimately that party will end up on the default list, which is becoming more and more complicated for those firms who are sitting on it because they can't access platforms like BCI or Cotton Made in Africa, et cetera, et cetera. So it is quite punitive, and it's becoming more so as time goes on.
The default list is the list of unfulfilled awards, part 1 and 2. And if I may sort of go and deal with part 2, would you care to do list 1, what that is?
Well, list 1 is the party that appears in the contract. So party A sells cotton to party B. There is a dispute. Party B says that party A has not complied with the contract. Party A, just let's say, call them London Commercial Inc. That is the name that will appear on the list of unfulfilled awards, part 1. Part 2?
Part 2. If you're listed, say Mr. X company is listed, and it's got subsidiaries that trade cotton. We will list those subsidiaries as being related after we've done extensive research from our safe trading team. We will list them on the list of unfulfilled part 2, and so if you're a member, you can't trade with those. We'll be dealing with questions very soon. We've made sure we've got 15 minutes at the end.
Let me ask you this next one, because I've been answering all the questions.
Well, that's very kind.
Is that all right? Yeah.
Next slide.
Oh, well, wait a second. We've got to go. No. Are we at question time?
We are at question time.
Oh, right. Okay. Well, so now it's Q&A.
And I will come over.
Hands going up.
To see if anybody's got any questions at all about what we've been talking about. Don't be bashful. One over here.
Jaffa. Hey, Jaffa, here.
My question was on the small claims arbitration. What is so you said $75,000 is the limit.
Yes.
For that, and approximately what is the process like? Is it still the 2 bites of the cherry, or is it? I mean, what does it entail, basically?
I'll let John answer that one, but I mean, as we've mentioned, it's one arbitrator. That's one fundamental difference. But anyway.
That's exactly right, Tim. It's a hell of a lot faster because you have the one arbitrator, so there's no conferring with anybody else. You still have the 2 bites of the cherry, so the arbitrator tendency will do 14 days going out to the claimant, puts the claim in, 14 days for the respondent to respond, and then there's a further second round of submissions as well. Usually, and in fact, we're seeing a trend that's only 7 days in which time to respond. So it's fast, it's furious, and in fact, the new Arbitration Act that's going to be brought in, I think, in probably a year, 2 years' time, will emphasize the importance of looking at sole arbitration.
Next question.
If there aren't any questions, I'll be asking questions of you. Anybody got any questions? One moment. If you could say your name and...
Hi, my name is Sashik. I'm a spinner as well as an agent working from Bangladesh. My question is pertaining to the current situation of Bangladesh, which is experiencing a lot of foreign exchange crisis, as we say. So all sorts of buyers is facing a lot of delays in terms of opening LCs, and it's a national crisis. So I'm just wondering if there's a force majeure opportunity in that, or how can we navigate this trying circumstances, which is out of the spinner's hands, for example, so that the shippers are also protected and the buyers are also can navigate it somehow.
Well, as I mentioned, force majeure does not exist in ICA bylaws and rules. It's a difficult situation there, because I certainly understand that subsequent to the contract being entered into, circumstances have prevailed that make it difficult for the contract to be complied with on a timely basis. But having said that, you've always got to bear in mind, A, the ICA does not cancel contracts. B, more fundamentally, there is the invoicing back process. And last but not least, the concept behind Rule 237, 238 is to place both parties in the same position that they were in when they entered into the contract. Granted, it's not the fault of the buyer if all of a sudden these sort of issues take place. Again, I would hope that calmer heads would prevail and that there would be some leeway and negotiation that would allow an extension of time, albeit under certain conditions. But that really is the situation between the buyer and the seller. But as far as ICA bylaws and rules are concerned, if a buyer or a seller, even for reasons that are beyond their control, are not able to complete the contract, the fundamental point is the contract will end up getting invoiced back and accounts will be made and settled as if no contract had been entered into at all. Both parties in the same position they were in the day they entered into the contract.
So as if it was completed the contract.
Exactly.
What we will have is it at market difference. It's invoicing back at market difference, and it's only if, in fact, you've got something in your contract that says we cancel out at par, and then it's at par that the agreement. But you've got to have that in your contract. Remember, force majeure is not in the ICA bylaws and rules. I don't see any further questions, Tim, so I think we're coming to the end of our session. Is there anything else you want to say?
Does that mean that we were so crystal clear that everything is completely...
Of course.
Okay. Well, thank you very much for attending, and I hope... thank you. No, I just wanted to end by saying that I hope that it's been informative, that you've learned something from this session, and I think it's a good process to do at each annual event, really, because there is a lot of misconception or misunderstanding about a process which really, once you get into it, it really is quite methodical. It's certainly very, very disciplined. But anyway, thank you very much for your time, and I hope you've enjoyed it.
Thank you.